Welcome to session 3 of day 1 of the second ASEAN Environmental Law Conference. Thank you so much for being here. And I know you're from everywhere, so good morning, good afternoon, and good night. For those of you who are observing the holy month of Ramadan, like myself, brace yourself. These are the late hours where where our patience is being tested. So the first 2 sessions earlier and one special session was they were very interesting, right? And our session, our current session is actually, if we are in the Southeast Asia, it's the gong of the day, because today we will talk about compliance and enforcement, future trends of environmental law in ASEAN, right? Okay, my name is Lindayanti Sulistiawati. Thank you so much for all the organizations that already invited me personally and Absel, the Asian Pacific Center for Environmental Law, Faculty of Law, National University of Singapore, as part of the partner institution to the event. I also teach in Indonesia. I teach at Gadjah Mada University, a Faculty of Law. And this is currently we have a very nice panel where not only experts, but we also have students. We have one team of students who, bless their heart, are going to have an exam soon. So they have to do their presentation first before our expert from Malaysia and Vietnam. So without further ado, I would introduce our student team from Universitas Indonesia. They are Gerhard Mangara, Matthew Nathan, and Valencia Katlea, who are all, I think, from the 3rd year, right, of the Faculty of Law, Universitas Indonesia. They are all under the Environmental Law Society in the Faculty of Law in their university. And both, 3 of them wrote a paper entitling The Prospect and Challenges of Climate Change Litigation Against Corporations in Indonesia. So this is a very sexy topic for Indonesia and also for ASEAN, because we have seen mostly CCL, the climate change litigations, took place against, the government in this region. But now with, the big landmark cases from outside the region, given us examples of how CCL can also take place against multinational corporations. I guess this would be the highlight of your presentation. And from what I hear, the lady, Alan Valencia, will be the speaker of the team. The floor is yours, Valencia. You have 10 minutes from now.
Thank you so much, Maria. Let me begin my presentation. First of all, my colleague Matthew will share the screen. Okay, so let me start the presentation. No challenge poses a greater threat to future generations than climate change. Barack Obama, State of the Union Address 2015. Greetings, ladies and gentlemen. We are from Environmental Law Society, Faculty of Law, Universitas Indonesia, an organization that focuses on discussion, research, and environmental advocacy in Indonesia. And on this occasion, we will present the results of our research entitled Prospects and Challenges of Climate Change Litigation Against Corporations in Indonesia. First of all, let me introduce myself. My name is Valencia Katlea, and I will present the results of the research carried out together with my colleagues, Gerhard Mangara and Matthew Nathan. So The following is an overview of what we will present today, as shown on the screen, which is divided into introduction, case study of the Mili Defensive versus Shell case, prospects and challenges of climate change litigation against corporations in Indonesia, and also conclusions. Next slide, please. So climate change has resulted in significant impacts and changes to ecosystems and human life, as shown on the screen. One of the parties contributing to this increase is corporate activity, especially 100 companies in the fossil fuel energy sector, which is called carbon majors, which releases greenhouse gas emissions into the atmosphere. Company activities and their impacts on climate change trigger reactions from certain parties to discuss corporate responsibility for climate change in court forums. Current developments indicate a new trend through the third wave of climate change litigation, which places corporations as defendants because their activities directly contribute to greenhouse gas emissions related to climate change with an interdisciplinary analytical method to prove the argument. So one of the landmark cases in the third wave of climate change litigation is the Mili Defensive versus Shell case in 2021, with issue and summary as shown on the screen. This is the first ever decision to hold fossil fuel companies responsible for their contribution to climate change and also to reduce carbon emissions in their supply chains. According to Peel and Markey Towler, several lessons can be drawn from the Mili Defensive versus Shell case. The first one is that almost all the NGOs and individual claimants involved had objectives aligned with similar interests of current and future generations of Dutch residents. The next one is the plaintiff concentrated on holding Shell responsible for its contribution to dangerous climate change, and also referred to the authoritative scientific findings of the IPCC presented by the applicants to articulate the impacts of climate change, especially on Dutch residents. And the third one is the court found that Shell actually has an obligation under the unwritten standard of care under the Dutch Civil Code to contribute to preventing dangerous climate change through the corporate policy it sets for the Shell Group, and also involved a direct challenge to the emissions reduction targets of a corporate entity. So from analyzing the implementation of climate change litigation in the Mili Defensive versus Shell case, which uses a rights-based and tort-based argument for climate change litigation, we have then concluded several prospects and challenges we may face right here in Indonesia. Firstly, we are going to discuss about the prospects. Despite still having a lot of homework in regards to mitigation of climate change, Indonesia actually has a really strong basis for climate change litigation. This is due to three factors. Firstly, Indonesia has acknowledged substantive and procedural human rights, especially the right to the environment in its regulation. Substantive regulations can be seen in many regulations, notably in an amendment of our constitution, specifically on Article 28H, which have taken into force since 2004. Also, we can see it in Law number 39 of 1999 regarding human rights, and also Law number 32 of 2009 regarding the protection and management of the environment. On top of that, procedural rights concerning access to information, participation in environmental decision-making, and access to justice have all been heavily regulated and protected under Indonesian law. The right to access of information can be seen to be protected in Law number 14 of 2008 regarding public information disclosure. The inclusion of the general public to environmental public decision-making and access to justice can be clearly seen to be protected in Law number 32 of 2009 regarding the protection and management of the environment, specifically in Article 65. So the second factor is the presence of the legal standing of non-governmental organizations and citizens as a form of procedural rights enforcement in Indonesia. So in contrast to the United States, Indonesia's regulations provide a more lenient requirements for their legal standing. The presence of this legal standing can be seen in a few landmark cases, such as Walhi versus PT Inti Indio Rayon Utama of 1988, which serves as the first ever case to acknowledge the legal standing of environmental NGOs in Indonesia, and also most recently in Komari et al. Versus Mayor of Samarinda, in which is one of the first cases where climate change contribution is acknowledged as a valid argument. Lastly is the implementation of the United Nations General Principles argument as seen in the Mili Defensive versus Shell case, which provides the basis of a business enterprise's duty of care in their line of work. Article 15 of the UNGP provides an obligation for business enterprises to identify, prevent, mitigate, and account for how they address their impacts on human rights, which includes the right to a good and healthy environment. So referring to the Defensive versus Shell case as a relevant legal precedent, and also Indonesia's high acknowledgement to substantive and procedural rights, makes this argument plausible in Indonesia's current litigation environment. These three factors have provided us a breath of fresh air regarding the development of climate change litigation in Indonesia. However, in reality, the implementation of these factors are not as easy as it seems. We have furthermore identified four main challenges that Indonesian law faces when it comes to corporate sins against the environment. The first one is the lack of progressiveness of the judges. So judges in Indonesia still fail to view human rights as a valid argument when it comes to environmental related cases. This obviously contradicts Indonesia's human rights bill. For example, let's take a look at last year's Indonesian citizen lawsuit against the Indonesian government regarding air pollution. The government was accused of unlawful acts for neglecting their responsibilities to maintain the city's clean air, which resulted in harmful pollutants, which is PM 2.5. The case was really big, but the judge's response made it seem like it's less important. The next one is, to this day, Indonesian law still doesn't regulate corporations' punishments for the damages that they cause to the environment. So because there isn't any law enforcement in this field, corporations often neglect their responsibilities to be environmentally aware. The third one is the fact that corporations in Indonesia still lack internal obligations on their climate change mitigation. They still view corporate social responsibility as just a formality rather than something that should really be taken seriously. This makes it harder to sue these corporations when they've done harmful things to worsen the climate change. Lastly, the ugly truth is that Indonesia's current tort law is sadly still outdated to accommodate a rights-based approach in climate change litigation, and realistically cannot connect the dots between the tort and the rights-based approach to climate change litigation. Environmental tort, as regulated in Indonesia's Civil Code and Article 88 of Law Number 32 of 2009, requires proving the causality between the unlawful act and the damages suffered. The practice of connecting legal due diligence to identify, prevent, mitigate, and account for impacts on human rights, as seen in the Defensive versus Shell case, currently cannot be implemented, as the argument was based on Dutch law. So to conclude,
we are sorry for the internet connection. Okay. So I will continue with this presentation. So to conclude, our research shows that the implementation of the human rights-based argument in climate change litigation case against corporation in Indonesia is plausible, as Indonesia has a good legal basis and knowledge that needs substantive and procedural rights. Indonesia law even views the right for the decent and healthy environment as a constitutional right. This is future supported in the strength of non-governmental organization and citizen in terms of legal standing, and you see the UNGP argument as a legal basis for corporation or business enterprise in Indonesia. However, there are still a lot of complication and obstacle when it comes to enforcing said law, especially regarding the lack of a progressive judicial system, rigid climate change regulation, lack of internal obligation for corporation in Indonesia, and the overall outdated tort law in Indonesia. This marks the end of our presentation. Thank you for listening.
Thank you. Thank you, Alan and Gerhard. Well, very good pick there, Gerhard. Good job. Okay, so I think, I think the students have done really good job highlighting the benefit and challenges of climate change litigations in Indonesia, and also drawing upon experiences from other countries. We're starting to have some questions at the Q&A chat box. So if you have questions that you would like to answer the speakers later on in the Q&A sessions, please do type your questions on the chat box. Thank you, students. So our next speaker is Pham Tanga, a visiting lecturer from National Economic University of Vietnam. Pham is a member of Vietnam Society of International Law, arbitrator and mediator of Hanoi International Arbitration Center, and adjunct visiting lecturer of National Economics University in Vietnam. Pham, you ready?
Yeah. Yes.
Yeah. Would you like to share your screen?
Yes, please. No, because I sent Colin already my presentation.
Oh,
So,
Colleen, can you help
yes,
share the screen
can you
for
send
Pham?
screen? Yeah. Sorry, I can use a virtual background of the
It's
poster.
okay. I like the poster that says "I love you."
Yes.
It's beautiful. Yeah.
This is the sun picture. Sun picture. When you visit Hanoi, you can make it by yourself. Yes,
Okay.
because I will go to the night market in the center of Hanoi, and they hold the market so people can buy the stamp and the picture with the image already. Yes,
Oh, good to
so you can
know.
use the color stamp, colorful stamp. Yes,
Sweet.
so that's
Okay.
fine.
So
Okay,
now it's
yeah.
5:14. You have 10 minutes, Pham.
Yes, good afternoon, good morning, and good evening. Somebody go from around the world. It depends on where you are. I'm from Vietnam. My name is Pham Thanh, and I'm very happy to present my research about marine environment protection in Vietnam. I will mention some of the facts and problems of marine environment in Vietnam. Then I give some recommendation or solution to solve the problem. Next slide, please. As you know that Vietnam is a coastal. Vietnam is a coastal country. We have a long coastal sea in the right of the Vietnam, and recent year marine activity in Vietnam coastal is developed very quickly because Vietnam is a export country, and we have many seaport, and vessels around the world can go here to do the import and export activities. So when Vietnam opened the market and import cargo from around the world, so the marine activity in Vietnam coastal developed very quickly, and this is impact very positive on the economics. But in the other hand, this activity makes some negative impact on the marine environment, makes some the pollution for the water, for the air and land also. It is necessary to protect the environment and implement the sustainable development goals of the United Nations. Follow that, Vietnam has enacted many legal policies to encourage the protection of marine environment to develop economics. And in this presentation, I will analyze the facts and problems of the protection of environment in marine activity in compliance with international and domestic law and regulation. Next slide, please. And in different station, we have a forming content. First, I mentioned about the ADG. The second is International Convention related to marine environment. The thirdly part is the facts and problems of marine environment protection in Vietnam. And the end, I give the conclusion and recommendation in the part 4. Next slide, please. The first, when we talk about the environmental protection, we talk about the SDG, the Sustainable Development Goals, also known as the Global Goals, were adopted by the United Nations in 2015 as a universal call to action to end poverty, protect the planet, and ensure that by 2030, all people enjoy peace and prosperity. And there are 17 goals. The first is the first goal, no poverty. The second is zero hunger. The third, good health and well-being. The fourth, quality education. The fifth, gender equality, sixth, clean water and sanitation. The seventh, affordable and clean energy. The eighth, decent work and economic growth. The ninth, industry, innovation and infrastructure. The 10, reduce inequality. The 11, sustainable cities and community. The 12, responsibility consumption and production. Goal 13, climate action. The 14, life below water. The 15, life on land. The 16, peace and justice, strong institution, and the end, 17, partnership to achieve the goal. And related to the environmental pollution in the sea, I want to mention in the goal 6 and the goal 14, life below water. Next slide, please. Okay, the goal 14, conserve and sustainably use oceans, seas, and marine resources for sustainable development. This goal related in the research of my research in this the problem of protection of marine environment. And you can read more detail about the content of the goal 14 on the website of UN. Because time limited, I cannot more detail, but you just find the goal 14. Next slide, please. And about the international law, I want to mention International Convention of United Nations on the Law of the Sea. This is a very important convention. It is the international law convention that have some article to provide about the marine environment protection. This convention has regulation for protection and preservation of the marine environment from Article 292 to Article 237. States have the obligation to protect and preserve the marine environment. You can read Article 192. States can take individually or jointly as appropriate all measures consistent with this convention that are necessary to prevent, reduce, and control pollution of the marine environment from any source using for this purpose. The best practicable means that their disposal and in accordance with their capability, and they send individual to harmonize their policy in this connection. States take on measures necessary to ensure that activities under their jurisdiction of control the conducted has not caused damage. And this you can read the article 194, especially you can read the article 211 of the UNCLOS 1982. This year about the pollution of vessel and the Article 211 mentioned the obligation of coastal country, coastal state must have a regulation and law follow the provision of UNCLOS 1982 about the reduce pollution in of the basin. And I think this the article 211 is very important for national law to give or enact some law, domestic law to require the foreign vessel and to protect the water and air in the sea. Next slide, please. Another important international convention is the International Convention for the Prevention of Pollution from Ship. In brief, MAPCON. The MAPCON Convention is the main international convention covering prevention of pollution of the marine environment by ships from operational accidental cause. The MAPCON Convention was adopted on 2nd November 1973 at IMO. The protocol of 1978 were adopted in response to a spate of tanker accident in 1976 to 1977. As a 1973 MAPCON Convention had not yet into force, the 1978 MAPCON protocol absorbed the parent convention.
Pham,
yeah,
your time is up.
Already? Okay.
Yeah. Do you have any conclusion that you want to share within 30 seconds?
No, next slide, please, because this international is a part.
Yeah, can we pass the international? Maybe just go to conclusion.
Yeah. No, not just a little bit. Here is the Vietnam legal system on environment protection, because we talk about the principle and performance. And I just give some international convention. It's made some the principle. And in Vietnam, we have a legal system on environment protection. And we will see on the screen that we have Constitution 2013 Article 63 have a provision that the state has a policy on environmental protection, manage and use effectively and sustainably natural resource, natural space and biodiversity proactive. And you can read more detail about the Article 63 of 2013 Constitution of Vietnam. That we know that Vietnam has a policy to protect environmental maritime. And we have some law like Vietnam Maritime Code 2015, law on environment and protection in 2020, law on natural resource and environment of sea and Iceland 2015, and the Penal Code 2015 have maybe a 10 article give us some punishment for crime, in environmental crime, maybe 5 or in jail, depend on the series of crime.
Yeah, thank you so much, Pham. I don't think we have time. You are already 3 minutes over time.
No, I think to the conclusion and recommendation.
Yeah, can we just do the conclusion and then we go to Dr. Siti next, because we don't have enough time. The students need to go for their exams.
Next slide,
can we just go to the conclusion slide?
Yeah. Conclusion and recommendation.
Yeah.
Here though, okay. We can see that now. Although how to say, because because I want to talk more detail about the how to say, because to perform because from the law to perform in the reality, we can see that in the implementation process there is still overlapping and interlacing function, leading to sometimes difficult coordination between the authority. Now, because when you see that the authority to manage the environmental pollution in Vietnam, and you see that there are many the authority agency manage this problem. So you can move to the slide 11. I want to show you the slide 11. You can see that the specialized agency for environmental management of support in Vietnam, because when you see the slide 11, you see that there are many agency manages. So when recommendation solution, I require that we should review, consider, and adjust the function and tasks of the management unit, and to ensure the clear identification of the lead and unit, coordinating unit, and the coordinating to principle between the unit. And about the support project, one of the subjects that will be given the 2020 law on environment protection, because when we increase the export-import activities, we build many new support in Vietnam. And when building support in Vietnam, we activities make pollution of air, water, and land. So to ensure compliance of the port enterprise, management unit needs to organize propaganda and dissemination guiding the implementation of new regulation. And at the same time, in order to proactive in pollution control and prevention of environmental incident of support, specialized management agency should consider and issue specific a guideline for port enterprise on the development of the port business plan, environmental pollution prevention, and response plans, environmental incident response plans applied to on support enterprise relevant organization.
Maybe Pham, maybe we can discuss this in the Q&A later. I'm pretty sure there'll be a lot of questions later.
Yeah.
Okay, thank you so much for the Vietnam protection law. I think we move forward to Malaysia now.
Yes.
Dr. Siti Hafizah, Dr. Siti Hafsyah Idris. She's a senior lecturer at the Faculty of Law, Universiti Teknologi Mangara. And she joined the Faculty of Law, UITM, in 2006, currently the Deputy Dean of Student Affairs at the Faculty of Law of UITM. So, Dr. Hafizah, no,
Siti,
sorry,
you can call me Siti.
Yeah, Hafsyah, right?
Yes, Hafsyah, yes.
Yeah, Hafsyah will tell us about eco-anxiety and climate litigation, which is like a good segue from the first presentation that we had from the students of University of Indonesia. You want to share your screen,
yes,
Hafsyah?
I'll share my screen now.
And you still have 10 minutes.
Wait, I do not, my screen, okay, I tried to share it. Yes, here.
You should have,
Okay.
yeah, the button.
Can you
Okay.
see my slide now?
Yes, yes.
Okay. Good evening to everyone, and good morning to from other part of the region. And my name is, as mentioned by Miss Linda just now, Siti from Malaysia. So the topic that I will share today is actually on eco-anxiety, actually and climate change litigations. So why I choose this topic is actually because recent study by Lancet by researchers in UK, United Nations, and then the result was published by Lancet in 2021, is actually saying that eco-anxiety, can you see here? Okay. Eco-anxiety, okay, particularly is actually, this research was done in the respondent from 10 countries with 10,000 respondents, aged from 16 to 25 years old, okay, youths, and then where the finding of this research was 60% of these respondents were very worried and extremely worried about climate change, and 45% they said that climate really affecting their everyday life, and quarter of them actually say that there is no future for the world because the world is dooming, and then 2/3 say that they are being betrayed by the politician, by the government, that they are believe that there is no action taken by the government with regards to climate change. So with this, we need to discuss what is eco-anxiety. So eco-anxiety is actually by American Psychiatric Association. They define eco-anxiety as the chronic fear of environmental disasters that come from whatever the impact of climate change and to the current and also the future generations. So this is the definitions. And then now we see what is the psychological impacts of climate change that can cause eco-anxiety. So as direct exposure to the consequence of climate change, such as disaster. So if you see, actually in Malaysia, there is no much research on eco-anxiety because less disasters happening. From my research and also my team research, our research, me and Dr. Jana. Dr. Jana is actually a psychiatrist. So from our research, many actually literature and came from Indonesia, because Indonesia is really feeling the anxiety, the anxious due to climate change, particularly because of the natural disasters. But Malaysia is actually happening recently, especially with the current episodes of sudden floods in the end of 2021 and also the early of 2022. So most of them from our survey, they think that they're so worried because what happened in the end of 2021, sudden floods happenings, and then there's no warning on that, and then when it happened again, a very heavy rains in the early 2022, most of the residents in the particular area, they were so worried, and then they send they are really prepared, and then they feel so anxious what going to happen. Are they going to be the same one as happened in 2022? So now actually in Malaysia we have this very hot weather and also very uncertain climate, because every day we have heavy rains, and they say sometimes it's very hot. So due to this, okay, we can feel, and then there's so many research actually embarking into eco-anxiety, whereas this actually research, this issue has been raised in the Western countries especially, and then they did a research, for example, the research that I shared with you just now. One of the respondent country is actually Philippines. So they chose Philippines to represent Asian region. So from this actually psychological impact, we want to know whether eco-anxiety is a medical condition or not. at the moment it's not categorized as a medical condition unless that the doctor, okay, can have all these symptoms, and then has a prolonged period that can affect the daily functioning, and it can relate to what happens surrounding them, that it can be categorized as anxiety or whatever mental illness, the category of mental illness. But the doctor has not yet, the psychiatrist and also the psychologist has not yet diagnosed eco-anxiety at the clinical diagnosis. Okay, so even though eco-anxiety is a mental health issues, okay, where they can lose control. For example, I did a survey among our students in your ITM, and then they said that with this hot weather, they lose control of themselves. They feel so easily angry and then depressed or whatever happened in their surroundings. So even though there is no empirical data, but at the moment they are now looking into the effective treatment. Okay, done with that, then with the medicals apart, now we move to the legal avenue. Is there any climate change litigations? So at the moment, actually, with regards to eco-anxiety, there is no specifically legal issue that been brought to the court on eco-anxiety. But there is a recent case in 2021 whereby there is youths, they file a civil suit. A complainant in 2020. Okay, a complainant filed a civil suit in the European Court of Human Rights against 33 countries. So this include EU member states, Norway, Russians, and also some of these countries. Okay, and then they allege breach of European Convention of Human Rights, Article 2, Article 8, and also Article 14. This article with regards to rights to life, right to privacy, and also prohibition of discriminations. So these are the things that been brought to the court, and then they already submitted the defense. All these respondents country, not responded. This respondent country already submitted the response, but yet to be determined by the court. And then with regard to damages, civil claim, and also criminal claim, of course, with this eco-anxiety, if this happening, if eco-anxiety is recognized, and also if the claimant can link it into this anxiety due to climate change, most of the companies actually they're so anxious actually what can be brought against them from these activities, especially with regards to industrial pollutions, and also the development that does not in compliance with whatever environmental law that in place in their countries. So actually the binding law mandating the cut of the climate change, there is law. Even though there is law, but of course, with regards to climate change, we still need to go to the, of course, to the human rights issues, and also on the rights to life, right to healthy environment, as mentioned in the been recognized by United Nations Human Rights Council, the right that everyone has a right to a healthy environment. So, but these rights not to be subjected to ill treatment, as mentioned in the case of in Portugal case, should be highlighted, so that not only youths but also everyone is aware about this eco-anxiety, and then there is a possibility of climate change litigation that can be taken against the companies or whoever actually caused the anxiousness toward these people, not only in that particular country, but around the world. So for way forward, we need to talk about it. We need to talk about eco-anxiety. We need to talk about the impact of climate change. Okay, what is the impact, not only physically, but also emotionally and also psychologically to the people that actually happening to them. And of course, now at the moment, the movement is among the youth, but at the Asian regions, it's not so much started yet. Okay, perhaps Valencia and then the groups can start this awareness amongst the youth, not only in Indonesia, but also in Asian regions. And then also we need to demand actions. Also, what is actually can be done to this climate change that happening surrounding, and it can impact to our mental issues and mental illness. And then, of course, there should be an intervention and frameworks to those who are vulnerable, especially for this very, if mentioned just now, Pham is actually mentioning about the goal, the target goal of Sustainable Development Goal 2030, and then there is a vulnerable justice to everyone. So this intervention and framework should not only benefit to these developers, but also to these vulnerable, especially youths, because they are the vulnerable one, and then also the people or the company or whatever parties causing this climate emergency should be held responsible. And I think that's all. Thank you for listening.
Thank you so much. Thank you so much. Okay, I think the bell didn't ring, but you knew exactly your time. Thank you so much, Hafsyah. Okay, now we are in the Q&A session. Thank you so much for those of you who already typed up your questions. We'll go with the Indonesian related questions first because the students need to take their exam, and then we'll wish them good luck after taking, our questions. Okay, we'll start with the first question from Hasbi Asidik. Hasbi Asidik is asking, how do you see the omnibus law with the orientation to make an ease of investment in Indonesia? Can that be a challenge for the development of environmental law and climate litigation in Indonesia? Gerhard, you want to take the floor?
Yes. So we assume the question is about a Job Creation Act as an omnibus law, right? Because omnibus law actually, if correct me if I'm wrong, is a method. Like we have many omnibus law in Indonesia, such as the newest is a national system, national education system as a bill. So as an omnibus law. So thank you for your question. So for the information on the Environmental Law Society have a policy brief about the impact of omnibus law orientation for environmental law and environmental litigation in Indonesia. I will share in the chat about this. You can see this and in LS in depth. So okay, it's in Indonesian language. So you can see about many critics from about this bill or job creation bill. We'll discuss about many points about this. The first is regulation based on risk, because the job creation act, we have regulation based on risk. So to identify in we have a job or we have a business, and this is what is the risky risks for the environment. Now, this many criticism of it is in difficult to define regulation, measuring objective, improper risk mapping, not testing risk, create and risk complex, and need many data to build about regulation based on risk criticism. The second is this bill of Job Creation Act will weakening environmental mandatory instrument in job creation, such as environmental permit to environmental agreement is different terminology with different effect. So if we environmental agreement, so yeah, okay, we will agree about your job, about your enterprise about it, and strategic environmental studies. So in Article 48 on this job creation law also only mandates that the preparation of the strategic environmental studies is carried out in drafting process on this spatial plans that establishes the function of preparing the strategic environmental studies in the evaluation stage of the spatial plan. Maybe Valencia and Matthew can adding this
Okay,
answer.
maybe I'll add to Gerhard's answer. First of all, am I audible because it's currently raining? Okay, maybe I'll add, before Gerhard have already explained about the impacts to environmental law in general, but to climate change litigation specifically, which we presented about, it doesn't actually impact it. It doesn't actually impact it very much because first of all, the omnibus law or what we call the Job Creation Act or bill, it doesn't impact the legal basis that we have explained before regarding the legal standing of non-governmental organizations or the citizen and others, but it impacts to sectoral industries like forestry or even environmental law in general, which opens a lot of climate change inducing activities. The first issue that I can tell you about is actually regarding the change to the forestry law in Indonesia, where previously there was an obligation for industries to maintain 30% of their watersheds and or islands in order to optimize the benefits of environmental, social, and economic conditions of the forest. But because of the job creation bill, this obligation was abolished. And actually, also regarding forestry is also the abolition of an approval from the House of Representatives regarding the designation and the function of forest areas, where right now it's allocated to it's only allocated to government regulation, not through the House of Representatives. So this regulation is very worrying because it provides potential massive land clearings in Indonesia, which where we already know forest fires and also land clearings in Indonesia is very already very prominent and also very concerning. So maybe the effects don't actually impact it directly, but indirectly it opens chances for companies or corporations to do more climate change inducing activities. Maybe that's our answer. Thank you.
Okay, thank you so much, Matthew and Gerhard. And the current omnibus law that we're speaking about, that we're discussing, is under review currently. So hopefully within 2 years, I mean maybe 1.5 years from now, the law would be better. I don't know. Okay, the second question for the students, I think you need to go after this, right? How was your experience, if there's any, on transboundary case or cases where one jurisdiction, whether it is Indonesia or Vietnam, has to enforce decision against party within another jurisdiction? So I hear Matthew, can you take the floor?
Okay, thank you, Ms. Linda, for the opportunity. Maybe I'll answer. We don't have personal experience regarding this case, transboundary case, but maybe we can take an example from one of the most prominent examples of water pollution or sea pollution, with the example being the Mangara case, which is oil spills occurring in Australian seas, but actually affecting seaweed farmers in Indonesia, in which most of the risks and also most of the damages received were actually impacted the farmers personally. Which is regarding this issue, there were already citizen lawsuits against the company in Australia, in which the citizens actually won and actually got compensation, in which this is regarding the choice of law in private international law too. And regarding that, there were also actually plans for the Indonesian government to actually sue the Australian company or Australian government regarding this issue. But this was actually later recalled because they don't want to impact the choices or impact the decision of the Australian court. So what we can actually take from this example is that, we can actually take from this example is that this is an issue of the choice of law in which we can actually use the law of the country where the corporation is actually inducing pollution or actually inducing the damages to our country, in which this choice of law is actually up to the people which the damages are given to. And this is actually, we can actually take this example from this actually regulated in the UNCLOS or actually other international regulations, in which maybe Gerhard can actually add to my answer.
Okay, thank you, Matthew. So the dots about connection about Mangara oil spill and in Indonesia is in Indonesia. Fishermen has claimed that the spill and is polluted the national waters and killed thousands of fish and caused skin disease and loss of human lives also. So and also NGOs in Indonesia expressed concern about the spill effect on Indonesia environment and traditional fishing ground, especially in West and East Nusa Tenggara fishermen. So this the concern from the Indonesia about this Mangara oil spill, and the Indonesia president in Mangara oil spill in Susilo Bambang Yudhoyono announced that Indonesian government will seek compensation from PTTE PAA because he believed that life of Indonesia with farmers and fishermen had been affected by Mangara oil spill. So this is I can.
Yeah, thank you so much, Gerhard and Matthew. That's a good answer. Actually, there's a famous case of transboundary haze pollution, but we didn't bring it to court. I'm pretty sure our colleagues from Malaysia and probably from Singapore also. You see Hafsyah is like, yeah, we should have sued the Indonesians, but it never gone to court. And we went the other way, went the diplomatic way and bilateral. And even we've gotten help from Malaysia and Singapore and the Philippines in order to for environmental restoration, so to avoid more forest fires in Indonesia. Okay, now we go to, there's one person here that we have in the attendees is having her hands up, Belinda Akelo. Would you like to ask your question live? Belinda, are you there? I'm going to count to 5. 1, 2, 3, 4, 5. I think she's not there. Okay, we're going back to the Q&A then. There's a specific question to Pham from Vietnam. Does your municipality laws, especially related to IUU fishing, have extrajudicial powers in dealing with encroachment of Vietnamese flagged vessels in other coastal states' maritime waters? So that's the first question. The second question is, does Vietnam has a specific law in relation to MPA? Please share your implementation experience. Marine protection areas, MPA. Pham? You're still muted, I think. Your mic is not on.
Okay, thank you for very interesting question and related to my presentation. But I think when I talk about the marine environment protection in is very the last scope, and the first time when I write about it, I want to mention about the activities of marine marine activities, especially activity of vessel near the seaport. But when you ask about the fishing, right?
Sorry?
No, because I think many the activities in the
illegal
marine,
fishing. Yeah.
Illegal fishing, right?
Yeah, illegal and undocumented fishing. That's what the question.
Yeah.
Is there any laws on that in Vietnam?
Yeah, Vietnam have a regulation related to the fishery, and have some punishment for illegal fishery. And when you can see that the Article 63 in the Constitution of Vietnam, they said that the policy, Vietnam have a policy on environmental protection measures and use the okay, I show you. Effectively and sustainably natural resource, nature conservation, biodiversity, proactive and prevent and combat natural disasters and respond to climate change. And the state encourages own activity of environmental protection, development and use of new organizations and individuals that pollute the environment, delete natural resource and degrade biodiversity must be strictly handled and have a responsibility to remedy and compensate for damage. And I think Constitution 2013 at the Article 63 give the obstacle, the regulation of Vietnam and policy of Vietnam to protect the marine environment, include against the illegal fishery, and we protect the biodiversity and be strictly handled and have a responsibility to remedy and compensation for damage if somebody gives some activity that illegal fishery will be punishment and must remedy and compensate for damage. And beside Constitution 2013, we have a law on environmental protection in 2020 and law on fishery. More detail about the regulation of fishery, how to fish legal and how to some activity restrict and illegal fishery will be banned in the Vietnamese coastal sea. And more about the law, we have a law on natural resource and environment of sea and Iceland 2015. And in the law on natural resource and environment of sea and Iceland 2015, we have a provision that protect the biodiversity of the sea, include the regulation of fishery and ban on the activity, illegal activity related to the fishery illegally.
Okay.
Yeah.
All right.
Yes. And moreover, we have a penal code 2015, Penal Code 2015, we have some regulation related to the crime that make illegal fishery on the sea, Vietnamese Sea. And depend on the serious of crime, will be punishment, can be fine or can be jail, depend on the serious of the activities.
Okay.
Yeah.
Thank you very much, Pham. Now we go to Hafsyah. Hafsyah, you have a lot of questions. I'm just going to read a few so you can answer them. The first one is from Hasbi again. Mr. Hasbi Asidik is asking how to count the eco-anxiety impact in a legal suit. So that should be how much damages we receive in monetary value. And then similar to the question from Mark Amer, he's asking, I can't begin to imagine the resources required to litigate carbon majors, particularly on the ground of eco-anxiety. Inter-country collaboration, I believe, is essential, especially to those countries that have suffered and continue to suffer the impacts of climate change, which basically are caused by the carbon majors and others like them. Do you have experience on this, and can you share it with us? Still muted, Hafsyah?
Thank you, Miss Linda. Okay, I will answer first the question from, because Lester asked two questions. Okay, both questions is actually similar. Can we use eco-anxiety as ground? Okay, based on our teams. Our team is actually, one of our team members is actually doing a research on carbons. Okay, her research is actually on carbons, and also is on a framework for categorizing carbon emissions. So yes, eco-anxiety can be one of the grounds. And then how to actually, whether I have the experience or not on eco-anxiety litigations, so far I don't have, but based on the cases, okay, cases actually been brought to the court, especially in the Western country, as I mentioned just now. Okay, for example, for Latin America, they are using actually rights to health. They use the ground of right to health, and then this includes not only physical health, but also mental health. And if you see the recent case on the one I mentioned just now, on Claudia Deota Agostijo and others, and versus statutory state, also under the rights of privacy, they actually claim that that right, and the right to privacy and right to life, because they were actually having physical and mental well-being. And then this mental well-being has been adversely impacted due to the climate change, because they have a difficulty in exercise, sleep, and carry out day-to-day activities. And then, of course, there's also a case in Canada whereby the plaintiff, 16 years old, she actually lived with GAD, generalized anxiety disorder, and also depression. So it actually, the climate change, whatever climate change crisis that happening in Canada actually worsens her mental health conditions. So yes, actually there are cases that have been brought to the court for climate change litigations, but as at the moment in Malaysia, it's not been tested yet at the court. And also with regards to the question on how to actually to quantify that. So to answer this question, actually, at the moment, there's no pending claim against the company on eco-anxiety. And then how to ascertain the damages on this ground is actually not yet been discussed. Okay, even the case just now in Portugal is also not yet been decided on the quantum of damages. And also a request for damages for eco-anxiety, whether should the state or the company be held liable, it won't be a surprise. There will be a measure for that. So as for now, the plaintiffs, most of the plaintiff actually asking that the company or the state to be punished on the ground they are not implementing sufficiently stringent environmental friendly measures, and they should forced to do that. Of course, in the one case, okay, French Supreme Court had recognized that people exposed to asbestos and also or to a medical devices that prove to be dangerous should be compensated for their fear of potentially developing in the future a cancer or other disease. But of course, as similar in the other cases, okay, to prove for compensation for damages and then also the loss for eco-anxiety is quite difficult to be quantified. That is why we really need to have a certainty, especially not only on international law, but also in the domestic law on recognizing eco-anxiety as one of the cause that we can put forward climate change litigations. Okay, thank you.
Okay, you're welcome. Hafsyah. So there's not yet any willingness to pay, some sort of methods that's been used to
Yes,
quantify.
yes, because we have to go back to the recognitions of eco-anxiety as disease, as one of the illness, mental illness, because
Okay.
as so far, clinically, it's not yet proven that this is part of the mental illness. So I saw just one question just now on physical and also what is the difference between people with eco-anxiety and anxiety. So there is also still debate and also argument on how actually to differentiate between a general anxiety and also eco-anxiety, because they really want to see, for example, now we have a lot of study, especially in Indonesia, in Philippines, and now in Malaysia, to really they want to have a link between whatever happens to climate change, okay, with what they are suffering now. Because sometimes people actually they already have that anxiety.
Yeah,
it may be maybe climate change just trigger the symptoms. So that is why we really need to go back to the clinical diagnosis. Then we can bring the case to the court if there is actually accepted by the medical board and also the psychiatrist association. Okay.
So it's related to the COP21 and COP26 about the Paris Convention, because you know that the Paris Convention 2015 about climate change, they give some requirement that reduce the greenhouse gas, right? Yeah, greenhouse.
Yes.
But US that withdraw from the Paris Convention.
Oh, not anymore. Not anymore. They're
yeah,
back.
Yeah.
Okay.
Come back.
Can we okay, there's one last question for the students before they have to go. So Fadli Gafar asked, how about the practical deforestation from the miners nickel company in Indonesia? There's much cost for renewable energy in Indonesia, nickel used for making battery, and we're still far off from net zero. I think he's just want to ask whether this is can be litigated. What do you guys think?
I think
Okay.
that,
can Alan answer?
Alan?
I want to hear her voice.
So we think that in practice, the use of nickel can possibly be bad for the environment, but nickel has a lot of potential and it's actually good for a lot of people in Indo because it's very useful. However, the government, I think, should actually regulate, and like the use of nickel should be heavily watched so that it doesn't cause harm. Maybe Gerhard wants to add.
Yes,
Gerhard?
nickel is useful for many things, such as a battery from solar panel and many
So
things.
the underlying question is, can this be litigated? Can this be a ground to litigate?
Yes, but if mining about nickel, because it's make a deforestation, right, to our country. So it can be due.
If they already have the permit?
Maybe Matthew can.
Okay, maybe I can help answer Gerhard and also Valencia
Thank you.
regarding this, the practical reforestation for nickel mining. Firstly, is that nickel is very useful for the for the production of electric vehicles, of battery of electric vehicles, and it is needed for the transition from fuel-based vehicles, electric-based vehicles to net zero in the long run. But in practice, in our transition to the usage of electric vehicles, there's also another problem regarding deforestation and also the clearing of the land for mining of the nickel. Regarding this, in our opinion, there can be two ways to litigate this problem. Firstly, we can certainly sue the mining companies regarding their actions that they actually severely impact the climate change. Climate change in Indonesia. Secondly, we can also actually sue the government of Indonesia for actually releasing the permits for these companies, because firstly we can because there's a presidential regulation in Indonesia to actually push for more electric vehicles in Indonesia, which actually allows for more nickel mining, more downstream activities for nickel, for the production of nickel. So there's actually two problems to this issue. Firstly, we need we can actually litigate the mining company first and foremost, and also we can also litigate the Indonesian government for releasing these permits. And also, other than that, we actually need severe regulations and also severe regulations with strict punishments for these companies if they actually use deforestation that actually impacts the environment. So the need for climate change regulation, and also the need for climate change and for the need for regulation to regulate these mining activities is actually really needed in Indonesia right now. Because as we all know, climate change is not only one-dimensional. We're actually we want to reduce our emissions from not only one source only. We're reducing emissions from fuel-based vehicles, but we are actually emitting more emissions from deforestation. So this is an issue we need to face as a nation in Indonesia, actually. Maybe that's our answer. Thank you.
Okay, thank you, Matthew and Gerhard and Alan. There's another caveat here from Gisela Greta. She's saying that we should check whether the companies have adhered to environmental compliance and then penalize them if they don't, which I agree. Okay. Good luck for your exam, students. Best of luck. I hope you all get an A. You already got an A from us. Okay. Not that it counts, but very good job. Okay, next question is directed to Pham again. This is from Mark Armour. He's asking about Vietnam and the Philippines territories have almost similar physical attributes. What actual experience can you share us in environmental cases involving enforcement of decisions of Vietnam courts against parties in other countries? Do you have any
scientific experience of Vietnam?
Yeah, like court cases that comes in mind.
I think that's each country have a legal system to protect the marine environment, and it's about the sovereign of each country that we can say. But I think that from the regulation of law to to enforcement and perform the law is the long path. The long path. We know that rule of law. Vietnam now try to perform rule of law. Each citizen have the right and obligation know about the international law and domestic law about about the marine environment protection in general, and another kind of law, and every citizen must perform the rule of law every day. Its activity includes the enterprise and individual when they make a business activity like import-export at the seaport, for example, make the fishery on the sea. They must know the regulation and law about the marine protection, and when each citizen, include individual and citizen, know about the regulation of law, they will apply and compliance. I think because this session we talk about the compliance of law, so I think experience Vietnam that when the government have the right policy, and train the knowledge about law to every country, every citizen in the country, especially citizens live in the coastal. They know about the law and regulation. They will have a I think that they will have a sense that rule of law is an obligation, and when they know about the law, they will comply the law better, and we should respect the law of each other, because besides the apply the domestic law, which each country should cooperate with another country, right? Because in the coastal sea, there are many activities related to the citizen from another country. So each country should cooperate with another country in the performing of law, to compliance with law and respect law of each other. For example, because some of the officers of Vietnam go to the international ocean, or go to Philippines ocean, maybe make some of the fishery activities, right? And maybe illegal or legal fisheries. But we should support each other, citizens of each country, and let they know the regulation of another country, so that they can comply and should respect the law of each other, especially in the Asian citizen, that we can go to the another country. So whenever we make some activity, we should know about the law and regulation of another country and comply it. So it's a good way.
Okay,
Yes.
thank you, Pham. I think there are like several questions here that are very general. I suppose Hafsyah can also Pham can help us answer this question from the MSU MSU Mak Des Gindol Ray. Is it possible to have a standardized international law in addressing concern of every country, given that every country experiences different factors and challenges
COC, DOC,
in implementing such internationalized law?
Yeah.
I
What
don't
do you
think
think?
so. I don't think so.
You don't think so? What do you
Yes.
think?
because the question actually has been answered.
No, because in ASEAN, we have a COC, DOC in the relationship with the China. And we know that in the China scene now have a conflict between the country. Yeah. So when we have a UNCLOS 1982, we have a COC, we have a DOC, but rule of law is not performed seriously. So that's why we have a conflict. It still exists now, and we try to solve this big problem.
Yeah, I think in terms of international law, I think the highlight of international law is that it's hedging upon the implementation of national law. So it is depending on the jurisdiction of the national laws.
Each nation now they have a legal system.
So I don't think international it's the international law intention to go into detail in each nation.
Environmental issues.
Yeah, especially environmental issues, because the landscape is different.
I think rule of law and compliance of law is a problem.
Like
now.
the basic
basically
spokens is the same, but when you go into more details, I think they should be, catered to national needs. So okay. The next question is a little sensitive. I don't know if any of you want to touch it, or maybe Matthew wants to touch it. Hi, Matthew. I see you there. What are your thoughts on foreign countries' continued marine dispute, like China to the Philippine Sea? International arbitration favors the Philippines in 2015, but China rejects the decision and continuously exploits the rich marine resources in the area. Anybody?
I don't have the expertise in this area. Perhaps Matthew will answer that.
Sometimes it's best to remain a bit quiet, except to know is the arbitral decision that the Philippines were successful in, and enforcement of arbitration is obviously a very important rule under international law.
Yeah, I agree. I think currently what's happening is that China is having bilateral discussion with the Philippines, and we haven't heard anything other than that. I think internationally, and the Philippines is not the only countries who are having bilateral direct discussion with China. I think Indonesia is also having it, Malaysia is having it, Vietnam is also having it. The South China Sea is the current ASEAN problem, you should say. I think they are also discussing it in the ASEAN level, waiting for China's involvement, I suppose, in the issue. Okay, I think I think we need to be extremely sensitive when we are talking about this, because this is more than just one issue, but like a plethora of issue. Once we start discussing about this, then it would open other doors to discuss, which is currently not our task, because we only have minutes left. Okay, our next question is to all the resource persons here. Do you have actual cases in relation to the enforcement of environmental case decisions that you can share with the audience? From Vietnam, I think we asked that to Pham already. How about Malaysia?
Yes, we do have the enforcement of environmental law, because we do have a lot of cases, and then we have a landmark case, Kajing to be case of course, with regard to enforcement of law, and then we also have many cases on wildlife protections, especially. So, and also currently we do have cases on water pollution, especially because due to water disruptions management, and it caused water pollution, and yes, it actually with regards to enforcement of law. And also when we talk about enforcement of law in Malaysia, we talk about the governance with regards to environmental issues. So of course, many stakeholders, when we had focus group discussion, they're really required, especially in Malaysia, for us to have a coordinations among the agencies to tackle the issues of monitoring and also enforcement of environmental issues, sorry. So with regards to this, even though we are having cases, judicial precedent, and also on the legislations and also bylaws with regards to protection of environmental issues, but we do have impediment and also challenges in implementing the law. But at the moment, we are complying with whatever international agreement and conventions with regard to environmental protections.
Okay, thank you very much, Hafsyah.
Linda, I could also just comment that tomorrow, I mean, this issue that Dr. Siti has highlighted in terms of some of the challenges we face, including access to judgments and court judgments and relevant court judgments. These are very challenging, and how we share them across jurisdictions and distill the principles. So tomorrow, when we look at environmental crime, and we'll be focusing a little bit on wildlife crime, which is very much a transboundary crime, and looking at some of the issues and some of the experiences that can be shared. And then in the afternoon, we'll also be looking at things like waste crime and water pollution, which also are, you know, they have this international feel, but there's also that local and domestic impact. And so I think that's where one of the challenges we do face is finding out those core judgments and core processes. And I know this is, of course, something that you've been doing, Linda, in terms of the work that the APSEL has been doing on looking at environmental courts and tribunals in the region, which again is one of the other ways of identifying, you know, processes where people can bring cases to their national courts. But we don't have a regional tribunal at the moment, or any regional approaches to bring a number of these cases to court or to any sort of arbitration process either. So these are all challenges that we face in environmental law.
I think besides the punishment include administrative punishment or criminal punishment. We should let the people or citizen, especially somebody related to activity environmental protection, that they know about the law and they understand why law regulate like that.
Okay.
More than just use the punishment.
Yeah.
Punishment is good way because the nature of
the
people,
deterrent effect, but also there's administrative
but I think
punishment.
the knowledge and understanding about the law is better than.
Yeah. Thank you so much for all the panelists. I think we've done what we came for today, for this session. I'm going to put the rein back to Matthew's hand, and thank you so much for both of you, and also for the students that have done really good job.
Thank you.
Thank you. Thank you so much.
Floor is yours, Matthew.
Yes, thank you.
Thank you very much, Linda, for moderating that session. We did have a range of panels in that session, and so range of topics. So we really appreciate the moderation. And more importantly, thank everyone who have maintained and participated to the end of today. Tomorrow morning, we start again at 8 a.m. with a keynote address from Amanda Cabrejo, who's an international legal expert, and she'll be talking about environmental crime and setting the scene for tomorrow, which is really a continuation of some of the discussion we've had today. And we'll be focusing very much on environmental crime, on wildlife crime, but also on waste and other transboundary matters. So I'd please urge you to join us tomorrow morning at 8 o'clock Bangkok time for the next day of this second ASEAN Environmental Law Conference. And again, thank everyone for participating, and thanks all the organisers and the support team for making sure that the conference works as well as it can do. And also thank very much our panelists. We really appreciate the time and effort that you've given and to put into developing papers. And finally, can I also make the observation that all of the papers and the presentations will be gathered together to put into a resource book that we will be publishing later on in April, so that all of these ideas can be kept and used over the next 12 months or longer, as the case may be. So thank you again very, very much indeed for all the participations, and for those also who are celebrating Ramadan. Peace be unto you, and best wishes for the next month. Thank you again, and looking forward to
Bye.
seeing you.
Thank you. Bye-bye.
Bye.
See you tomorrow.